Oh, I can hear you.
Hey,
Okay. We have launch. Lindsay versus Lindsay. Both parties are present via Zoom. Ms. Wilsner is present here for the plaintiff mother. This is dad's custody motion. From what I can gather, it's really only asking for Peyton. There are two children, but everything relates to Peyton. It says that on the weekend of 8/25, the mom didn't show up to pick the kids up until 11:25 at night, and then showed up the next day at 9:05. He didn't give her the kids, and Peyton says she feels unsafe at mom's house. Dad, I don't know. Dad tried to enroll the kid in school. When did you try doing that, sir?
The following week, sir. She said she was unsafe to go home for several reasons. I can list them if you want. And then, so I wasn't sending her home, and until we had a court date, I was trying to get her in school so she didn't miss school.
Well, then I know the mom came and asked for an ex parte to get the child returned. Where is the child now?
She's sitting next to me, sir.
Don't have her sitting next to you. This is not her issue. She should not be there.
Go to your room.
Your Honor, if I may provide a little bit more context.
Yeah.
Okay, thank you. And I apologize to Mr. Lindsay. I just entered my appearance late afternoon, so I wasn't able to send it to him. I didn't have his email address. But from my understanding of the case, the parties have a stipulated parenting time order with a parenting time exchange plan that allows for every other weekend. My client has full custody, legal and physical custody. Mr. Lindsay has, like I said, every other weekend. They're supposed to meet in Muir, which is a halfway point or some point somewhere. During the weekend, my client did arrive in Muir at 6 p.m. to meet him to get the children back. Unfortunately, he said, come to my house instead, because the previous Friday, he had gone all the way to Grand Rapids because of a car issue from my client. So my client was at the pickup spot at the time that she was supposed to be. He refused to bring them. He refused to give them to her that night when she arrived at his house. And then the next day, only one child came home with her. The 13-year-old apparently refused. And my client has stated that she is making some comments to her that seems like she's being coached by someone. I'm not blaming anyone about that, but I think it's a 13-year-old. They're going to be a little contrarian about their wishes in regards to their residence. The biggest issue, of course, is that this child has not been to school since August 25th. That was the weekend that the child had parenting time. And since then, she has not been to school. My client has contacted her school to let them know that she's not doing anything wrong. She can't get the child back. She tried to file an ex parte motion. It was denied. And we are here today for a custody change. The allegations in the complaint are totally untrue. They seem to be said only by the child. None of the things that are listed that the child have said, my client adamantly denies them. The only thing that has any sort of substance is that, yeah, sometimes she spends an overnight, my client does, with her boyfriend, but the kids are not left home alone. There is an adult friend of hers who also lives at the residence, who takes care of the children when she's gone. Other than that, there's absolutely no reason for a change in custody here, primarily because this child is being withheld from her. He was only supposed to have parenting time, and now he is refusing to return the child. At this point, I think his motion for change custody should be denied, and this isn't a parenting time complaint violation, but the child needs to be back in school immediately, and I think she needs to give the child back today.
All
Sir,
right,
if I might speak, sir.
yes.
I have tried to get her Chromebook for her school from Michelle. She refused that. I sent Peyton to school, and she was sent back home because they sent a custody agreement from the school. I have tried everything in my power to get this girl in school. She even went to school, sir. She's been
The school she's enrolled in?
No. I live 2 hours away, sir. She's behind on her appropriate shot since the age of 4. She has no insurance. She's not safe or happy. Michelle hasn't had a job in months. She refused to let Maddie come over on my time. She let Peyton get drunk with her 2 to 3 months ago. The girl's 13. Michelle punched her in the back and choked her.
No.
There's 9 people living in the house.
Your Honor,
And
if I may just add,
when she did show up, Your Honor, it was 11:30 at night, and I told her that she needed to come when the girls were awake at a decent time. She didn't show up to 11 o'clock at night when the little girls were in bed, sir. The only reason I have this little girl is because she was crying and felt unsafe to go home.
Your Honor, the kicker in this case is that Mr. Lindsay has 4 felony pending criminal charges right now in Saginaw County.
I do not. You're wrong.
I have seen you have a pre-trial scheduled in November. I've seen the docket.
For one, not 4, 1.
It lists 4.
It's 1.
And
Call my lawyer.
7
Call my
counts.
lawyer.
All right. Anything else?
There's multiple CPS cases every year, all year.
Are they substantiated and are they open?
No.
They were. Most of them were. Some of them included touching of the children.
Resources to help pitch in where I might have been falling short on, because we're human. No one is perfect. No one's going to have it 100% all the time. So I was offered resources that I took to help the girls.
Ma'am, investigation doesn't mean any more than Mr. Lindsay is charged with a felony. I don't convict somebody based on that, okay? So the bottom line is everybody has got to follow the court orders unless and until something is changed. That means Peyton has to go home. And if I need to enter an order to do that, I'll enter it and I'll allow the police to pick her up. She has to go home because I cannot change custody on Friday morning. I'm not allowed to. I'd have to have an evidence.
You can't talk to this little girl yourself, sir?
No, I'm not going to talk to a 13-year-old. This is about the parents and stuff. And a 13-year-old,
parent is failing, sir.
Stand there and tell me anything she wants, but that's not appropriate. I'll have a hearing if I have to, and then I'll talk to her, but not today. In the meantime, she must.
Well, I want a hearing then, sir, because the girl's getting drunk with their mom at 13.
No, she's not.
Yes, I did.
That's taken entirely out of context, along with everything else that you were claiming, because you're getting information from a 13-year-old, of which is telling you what she thinks you want to hear.
Well,
and I am not failing. I don't have.
You gotta stop, ma'am. Ma'am, you got an attorney who's representing you. You're not going to argue this out. All right. I'm trying to determine if there is an open CPS investigation. It still is going to require that the girl has to go home and follow the orders until we have an evidentiary hearing. If we have an evidentiary hearing, that's the bottom line. Okay. And all I'm trying to find out is there an open investigation? Where is it going?
yes, they were just here, sir. CPS was just in my house investigating for her house.
Your Honor, I have no information about this, so
I can elaborate on that if you would like me to.
You what?
I can elaborate on the CPS investigation.
No, I don't want to. You elaborate to your attorney and tell her what's going on so she can investigate it and
Absolutely.
Whatever. All right. So at this point, I cannot and will not change custody on a Friday morning. She must get home and she must go to school. End of story.
Well, she told me if she goes home, she's gonna run away, sir. So I'll bring her home and she's gonna run away.
She's telling you what she thinks she wants.
I'm just telling you how the little girl feels. I'll bring her home, sir.
I'm not doing this arguing thing.
Well, yes, you are. You're sitting here arguing the whole time. Just stop. She'll be returned home. If she runs away, she'll probably be picked up as a delinquency ward and sent to, I don't know. So that'll happen. As far as we will have an evidentiary hearing regarding threshold only. You have to show proper cause or change of circumstance, sir, to even enable you to go further in it. We'll have what's called a threshold hearing for you to prove that there is proper cause or change of circumstance to try and change the custody. You'll be sent notice about it. You're going to be way far behind the 8 ball if you don't have an attorney, because it's going to be an evidentiary hearing. You're going to have to present proper evidence. You're going to have to exchange witnesses and all that stuff ahead of time. Make sure you follow the order that's going to come out.
You can come get Peyton.
All right. Yes, sir.
Ms. Wilsner, you draft the order, please.
I will. Thank you, Your Honor.
All right.
Well, can she come get her, sir? Because I'm a foreman. I need to go to work and she doesn't even have a job.
I do. Thank you.
Why don't you meet at what time? It's supposed to be normally at like 6 o'clock. Don't you guys meet in Muir at 6 o'clock?
Yes, sir. Unless I pick them up from her house and then she comes to my house, because the travel is equal in the order.
Well, the last time she drove to your house, she drove to it twice and didn't get the child.
Well, she showed up at midnight, sir.
I don't care. She traveled there twice and didn't get the child. So the bottom line is she has fulfilled her 50-50. You can meet in Muir at 6 o'clock.
I'll put that in the order.
All right. Good luck. Thank you. Gilgisford versus Costello. Both parties are present with their respective attorneys, that being Ms. Rademacher for the plaintiff, Mr. Scazzari for the defendant. We also have guardian ad litem Stacy Van Dyken present. This was mother's plaintiff's request regarding legal custody. I think for the court to have an evidentiary hearing to determine whether that joint legal custody is still appropriate. That's the first request. That looks to me, even from the answer, that there's proper cause or change of circumstance to have an evidentiary hearing regarding legal custody. Mr. Scazzari, I assume you don't need to add anything at this point. Ms. Rademacher, Mr. Scazzari.
I don't think I need to add anything, Your Honor. I think I would just rely on our brief.
Ms. Van Dyken, can you add anything to this? I mean, quite frankly, these people, they don't even agree. I can't even figure out if they agree on a method for breathing treatments and stuff like that. It does appear to me that the parties do not cooperate or don't get along very well, and I should take a look at legal custody.
That would be my take, Your Honor. I think prior to the hearing, I can supply the court with my recommendations and investigation with regard to the different physicians, counselors, etc. So I do believe that you are spot on about the communication between these parties and following doctor's directives.
All right. Well, I mean, I do find that there is proper cause or clearly change of circumstance, but proper cause to deal with the issue of legal custody, and we'll set up an evidentiary hearing regarding legal custody. That's not a guarantee that it goes to either party one way or another. It's I'll evaluate it, and whether it goes to plaintiff or defendant or whether it stays the same, I'll make that determination. The other issue regards a psychiatric referral. Is that correct? And Mr. Scazzari, what's your position on that?
Our position, Your Honor, is I think simply what the parties have been dealing with prior, which is I think there's a difference in interpretation of what the evaluation simply says. I think there is, Ms. Litchford believes that the children should be on some form of medication. And my client, Mr. Costello.
Evaluation does not mean medication. I mean, no. It can, don't get me wrong, but it doesn't mean automatic.
Right. Well, Your Honor, I mean, I think an evaluation has already been completed. And I think that Mr. Costello's position is that the children just need to follow some of the coping mechanisms and strategies that have already been suggested before going any further.
When was that psychiatric completed?
It wasn't. There is none. It's psychological evaluation by Dr. Wolf in 22, the children have been in counseling with Miss Martin since that time. And she is recommending the referral pursuant to Dr. Wolf's report and her own assessments, in addition to the school.
Ms. Van Dyken, is that your?
That's my understanding as well, Your Honor, that was a recommendation out of Dr. Wolf, the counselor, for a psychiatric evaluation.
So why wouldn't I order a psychiatric evaluation then, since it's recommended?
I think you should. That would be my recommendation to get that completed. And again, it's just an evaluation. We can look at the recommendations from the
Look at
psychiatrist.
the recommendations when they're done. If the doctor says they should be on medications, you can file. I mean, that'll be a joint legal decision, and we'll eventually figure out whether there's going to be any joint legal. Mr. Scozzari?
Your Honor, I think the only thing we would say is that I think this was Miss Litchford's request for that referral. I think Mr. Costello's position is that he didn't believe that referral was needed in the first place.
Well, I'm going to take the advice of, I'm going to take the road of least resistance, which says we will order a psychiatric evaluation for the kids. That does not mean that the kids can automatically be put on medication even if the psychiatrist suggests it. At this point, obviously we'll have to have hearings on this because the parties are ridiculous and that they can't get along on anything. So we'll order the psychiatric evaluation. Anything else you want? There's a proposed order regarding a breathing treatment that's attached to the motion. Mr. Scozzari, does your client agree or disagree with that order?
He disagrees with that, Your Honor. I think that would go to the legal custody issue that we can probably figure out after the evidentiary hearing.
Ms. Van Dyken, do you wish to weigh in?
I do, Your Honor. That is the proposed recommendation of a breathing treatment when the child has these issues. I think we should follow it. I don't think this is a joint legal custody decision. I think you follow the recommendations of the physician for that breathing treatment. So I believe that the order is correct, and I know that we have been trying to get this order entered for quite some time to have the protocol followed.
And Mr. Costello just doesn't want to follow the protocol?
Your
Correct.
Honor,
Go ahead.
sorry. I didn't mean to cut you off, Stacy. Go ahead.
He has a differentiation about when to start and when to stop the protocol, about what length of time. It's clear in the recommendation it should go when it starts for 10 days. And he feels like they're fine after day 5, he doesn't follow through. So I go with what the doctor recommends. If it's a 10-day treatment program, it's a 10-day, even if he's feeling fine.
And Mr. Scozzari, I don't know why. I don't know why I wouldn't follow the doctor's recommendation, at least in the short term, until we get to have a hearing. I don't even know whether or not the treatment will have to be produced during that period of time. I'm not sure when we'll get in, but it seems to me that this is what everybody says the doctor says. Mr. Costello doesn't like it, but it seems to me that this is what the doctor is saying, and they're just trying to make sure that both parties have to follow the treatment plan of the doctor. Does your client think he knows better than the doctor?
No, respectfully, Your Honor, I don't think he has an issue with the actual breathing treatments themselves. I think it's his interpretation is that, or rather the way the breathing treatment is supposed to be followed, is that there is protocol before medication is given. And I think there's some concern with the steroidal medication being overused in Miss Litchford's interpretation of that protocol. My client doesn't have an issue with the protocol whatsoever. I think he just wants it followed to the letter.
Well, that's basically what it's saying, is it has to be followed to the letter. There's no question in my mind that it has to be followed to the letter. Nobody can deviate from it. And so, and Ms. Van Dyken, does this order, because I don't know the treatment plan, does this order follow that?
It does.
And that's your understanding of what should be done?
Correct.
then I'm gonna enter that order. We'll deal with any other issues as they come up after when we have our legal custody hearing, our evidentiary hearing on it, because then it'd be appropriate to take a look at it. But it seems to me, since everybody agrees they have to follow it absolutely, then everybody has to follow it absolutely. All right? Any other?
Your Honor,
What?
if there's an issue in the order of one of the parties not following it, absolutely, as the court just indicated, will we deal with that at the evidentiary hearing, or should we deal with that in a show cause?
I'd kind of leave that up to you. We
Certainly.
can deal with it at the evidentiary hearing, but if somebody is just blatantly violating the order, you can bet that a show cause will be, I would think, would be filed by either party, unless it's 2 days before the evidentiary hearing, then you'd want to deal with it. But I would think that you would file an order to show cause. Both attorneys would if it was violated. And I'm sure Ms. Van Dyken needs to have the notice so she can make some preliminary determinations whether somebody is violating it. I find this all very, very disheartening that I've got to become involved in breathing treatments for a kid when we've got adults who just we got to follow physicians, whether they're right or not. I can't tell you that, but unless you make a appropriate objection to something that the physicians want followed, I don't know. All right, I'll set up an evidentiary hearing regarding, and I will sign the order that is attached to the motion.
And do you, I don't know if Dr. Wolf or the therapist had a psychiatrist within Brains that they referred?
Either Helen DeVos or Pine Ross.
They recommended Helen DeVos or Pine Ross.
Mm-hmm.
Could maybe Ms. Van Dyken provide a recommendation referral to the parties based on the therapist and or Dr. Wolf's guidance?
I'm happy to do so, Your Honor.
All right, and the chances are extremely high that I would follow her recommendation unless you have some objection to it that you want to bring on, but I can't imagine why I wouldn't. Miss Van Dyken will come up with a recommendation as to who, and unless you can show some clear bias, we'll probably follow it. That's just giving you some heads up. All right.
Very good. I will draft an order and the court will sign the breathing treatment order, and I imagine distribute it here.
Okay. Can you? All right, I guess I just have to have from the prosecutor's office. Pull this on. This is her request for judgment of paternity. I did see in the file that there's a 99+% chance that the defendant is the father. And you have gone through the imputation factors regarding plaintiff at $15 an hour times 35 hours. I had reviewed those and then they appeared to be appropriate. The defendant has VA military disability at $1,800 a month. And as a result, you have calculated the child support. Is there anything you would like to add? Looks like child support of about $267.
Yes, Your Honor, briefly, thank you. Your Honor, this case was filed on April 18th of this year, and service was proper on the defendant on May 16th. We did receive a response from the defendant on June 14th, and he did request that genetic testing. And as you so put, they did do genetic testing. He is the biological father of this child. Your Honor, I did hold a pre-hearing conference with the parties separately. The plaintiff is requesting back support in this matter, which the defendant was not happy about. I did explain to him that should he participate in the hearing, that's something he can bring up. But as he's not here, I am going to place that on the record that was his objection, was the effective date of May 1st. I do believe that the documentation is appropriate. To me, it was just the effective date that the defendant was not in agreement with. I did impute the plaintiff to 15 an hour at 35 hours a week. She's currently attending school to become a medical assistant. So when that does change, I'm sure the calculations, when she becomes that medical assistant, I'm sure the documentation will change at that point. But for now, I do believe all the documentation is appropriate and I'm requesting entry of same today. Thank you.
So he really didn't find out he was the father until 1st of July, correct?
Correct.
All right, I'll make the effective date July 1 for that, since that's when he basically found out that he was the father, and I wouldn't expect somebody would be paying when he didn't even know for sure that he was the father.
It may be that the letter was sent to him a little bit later than when the genetic test result came out. I can dig for that date if you would like me to.
That's an appropriate date. That basically splits the difference anyhow between now and then. But he did know at least it was proven that he was the father around July 1st, and from that time on, he should be paying child support. So I'll make the effective date July 1st, and other than that, enter the order when it is presented to me.
Thank you, Your Honor. I'll make that correction. And then I will re-sign the judgment of paternity and the UCSO for today, since we are amending that. And then I'll have it sent to you via DocuSign later today.
Good. Thank you very much.
Thank you, Your Honor. I appreciate your time.
Hello, everybody on YouTube, from Romania to Traverse City to local. Yeah. Now we've got a favorite YouTube person, that being Mr. Cox on.
Good morning, Your Honor.
Good morning. Can everybody hear me?
Yes.
All right, Hunter versus Field. Mr. Hunter, Miss Field are both present, as well as Mr. Cox representing Mr. Hunter. This is a date and time for entering a default judgment of custody. Mr. Cox, I assume your judgment speaks for itself, and you're asking that it be entered because there was a default.
There was, Your Honor. And I know that you are going to be shocked to learn this, especially, someone as stunningly and handsome, as smart as I am, but I did not serve Miss Field at the correct address. I served her at an old address. So she is correct about that. She did call us yesterday, brought it to our attention. We did email her the judgment. So, Your Honor, if she's happy with the judgment, that's great. If she's not, we probably have to adjourn for a couple of weeks for me to give her proper service, and maybe I can talk to her in the meantime. So that's where we're at.
Field, Mr. Cox admitting to a mistake, but have you looked at the judgment, ma'am?
I looked over it. There are a few things that, I'm not in agreement with. As far as the FOC order that was signed by Judge Hillary, what do we do about that in the meantime?
What FOC order that was signed by Judge Hillary?
So, Your Honor, you can kind of fill in here. Friend of the court issued a recommendation and neither party objected, so that was entered. And our judgment, and the only thing our judgment does differently from the friend of the court, it's still equal parenting time, is that it does tweak what my client describes as the reality or the more convenient timing schedule. But I would indicate that the defendant did not appear at a settlement conference, and that's how we were able to get the default entered against her. So this is a default situation. And again, I'm happy to try to talk to her over the course of the next week or two to resolve some issues, but probably we just need to adjourn the motion, Your Honor, until your next available hearing date. And then I'm happy to try to work on those issues of concern with her.
Ms. Field, you're kind of lucky in that Mr. Cox is even saying he'll work with you because he's got a default against you, okay? And he doesn't really have to, but knowing that it's always best to try and figure these things out.
Right.
He will I'll adjourn this for, well, I'll let you renotice it, Mr. Cox, whenever you want it, okay? If you want
Thank you,
it
Your Honor.
2 weeks
Thank you.
from now, you can. If not, 4 weeks, whatever. Let's get this matter resolved. And Ms. Fields, understand that you have been defaulted, okay? But let's see if we can get everything worked out, okay?
All right, and just to confirm, Your Honor, I apologize for interrupting the court. Ms. Field, do I have all of your email stuff when you communicate with my staff yesterday? I just want to make sure that I'm emailing you. And
Yes, everything should be up to date, and that's usually how I communicate with you guys is through my email. So.
All right, and so obviously, we know I screwed the address up once. Let's not do this twice. I won't say the full address, but are you at? Thank you, Your Honor. Nothing further.
Right, good luck. Thank you, everyone. Take care. Have a good week.
Good to see you and have a good weekend.
Good to see you. Thank you. Party versus Pant. Both parties are on Zoom. Miss Party, whose name is now, I believe, Andrews. You were able
Yeah.
Yeah, you were here earlier in the
Yeah.
courtroom, but now that's fine. This is a custody motion by father, primarily about Caden.
Mhm.
And that dad says that Caden has been living with him for the past couple months. That there's been some difficulties between mom and Caden. And that he's asking for a change of custody. Ma'am, has Caden been living with you for the past couple months or with Mr. Pant?
No, I allowed him to go stay with Mr. Pant about 8 weeks ago.
Okay, so he's been there for a couple months, just like I said, right?
Yes.
So that would certainly provide proper cause or change of circumstance to have a evidentiary hearing regarding change of custody. But do you agree to change custody for Caden? Just for Caden?
I do not.
All right, then I guess we'll have to have an evidentiary hearing on it. Sir, it's clear that if Caden's been living with you how old is Caden?
He's going to be 17 next week.
All right, it's clear that if he's been living there, that's a change of circumstance or proper cause to allow for me to have an evidentiary hearing as it pertains to Caden and the change of custody. As far as the other children that I believe are twins.
Yeah, they are.
Mr. Pant, you make some allegations about mom and that she called you for her food and that she's drinking excessively and had a sex offender around and was living in a 2-bedroom apartment. Well, as far as the sex offender in the 2-bedroom, I don't know when you're talking about. Is that recently, sir?
The sex offender that she was, I believe, married to was actually years ago. She is divorced now.
Then that's nothing. Ma'am, I don't, and as far as the, I mean.
I haven't
it's
seen
not
this
relevant
motion at
anymore.
all either.
What?
I have not been served the original motion, so I have no idea what his basis is. So I'm going into this blind, and I had that statement prepared to give you an overview of what's going on. But I do think it would be beneficial to just have an evidentiary hearing so I can hire an attorney and move forward that way, because there's a lot of things that I'm not aware of here.
Sure, what are you saying?
I would say I don't really see a need of her needing an attorney. I have,
Well, she's going to, because you're going to get into an evidentiary hearing and it's a hearing in which only properly admitted evidence, you're not just coming in and talking. It's going to be witnesses sworn in and whatnot, and you're going to have to admit evidence appropriately. There's going to be a scheduling order, which is going to require a trial brief and exchanging of witnesses and evidence prior to the evidentiary hearing, which I'm clearly having as far as it goes to Caden. And if both of you don't get attorneys, you're fools, because I don't think you know how to do this.
that's fine. I thought that the evidential proof that I've given already was going to be documented for today. her basically stating that she wants nothing to do with him. She would sign off on
That's
him.
just, that isn't properly admitted evidence. That's just something that you make your claim that, I say, okay, there's probably enough to have an evidentiary hearing, at which point now it becomes, evidence that you have to produce. That's not evidence that I'm going to take. You're gonna have to prove it.
Okay, that's fine.
So, it appears that there is proper cause or change of circumstance to allow for an evidentiary hearing. We can have it regarding all three kids, as there are allegations of, drinking and needing food and things like that, that I don't really know whether or not they're true or not. As far as stuff like sex offender and that kind of stuff and living in a 2-bedroom, I'm not gonna, it's way too late to be talking about that. If she was married to a sex offender years ago and now suddenly, I'm not gonna use that evidence against her.
Well, I would like to bring this up. This is actually something new that happened. Caden's grandfather actually gave me paperwork at his soccer game the other day stating that Ashley signed off some kind of rights to him, and he is an actual sex offender as well. I don't see how she could really sign off any kind of rights.
Giving up your rights at all. I don't know what kind of rights. I mean, a guardianship or what?
That's untrue. My grandpa presented a POA at his soccer game yesterday.
I can hardly hear you. Lean in. I can't hear you. All right.
Can you hear me?
Yes.
I offered a power of attorney to give him, legal rights for doctors, dentists, schools, things of that nature. And he rejected it. He wants physical custody, and that's that. And to even bring my grandpa up, Adam's been involved with my grandpa.
Why did you give your grandpa a power of attorney?
I didn't. My grandpa was involved with Adam this whole 8 weeks. Apparently, I just found out the other day. And my grandpa was at the soccer game and talked to Adam last night and proposed that I would be willing to offer a POA because Adam has asked for it this summer. And I did offer that, and he rejected it.
That's a lie. You signed the paperwork, and I have.
I didn't sign any paperwork and also with this motion he filed, he's not even giving his actual current physical address. He's giving his dad's address. I have no idea where even Caden lives, and he won't disclose it. I have to have an address to prepare paperwork.
That's
I'm going to set an evidentiary hearing, and I'm going to tell you that, sir, you got to have the address where the kids are living.
I did give the courts my address. I didn't give her my address.
And I'm entitled to know where my son is living. I have full rights to him.
She's entitled to know where her son is living. Don't shake your head. She's entitled to know.
She hasn't called him in over 4 months.
He won't give me his phone number or his address, and I couldn't even send CPS there to see his living conditions because I have no idea what his current address is.
It's fine.
He gave a Wayland address. He lives in the Coopersville district. They asked me to enroll him in Coopersville because Adam didn't have the legal authority to enroll him in school.
Ma'am, just stop. Sir, do you live in Wayland?
No, I live in Talmadge Township, Grand Rapids.
Why would you give an address where you're not living?
I did give the courts my physical address where I do live. The paperwork that I sent to her has my mailing address.
All right, well, she needs to know where Caden's living because he's staying with you full time. You can give it to her.
She kicked him out on the streets.
I don't care. I just told you. She needs to know where Caden's living.
That's fine.
And so when we finish with this, you probably have email addresses or text or something like that. You'll have to give her the address where Caden is living. End of story. All right?
Yes, sir.
Thank you.
But other than that, we'll set up an evidentiary hearing. It's going to be a while. We'll see you all. If you don't have a attorney, you'll be.
I have one.
So I'm just telling both of you. We're adjourned. Thank you.
Thank you.
Quano versus Quano. This is a case that was assigned for Judge Hillary to hear because he understood that it was basically a de novo review. Only after having looked at it, he said it's really a request to clarify the order, and that should be done by the person who ordered it, which was me. And so he sent it down to me now with the understanding that I really have not read anything. I will. And Mr. Quano, I'll just tell you, you sent in an 11-page document at 5:30 last night. I don't know when you think somebody's going to read this document when the motion is set for 8:30 in the morning. It doesn't even comply with the court rules as required for an answer. It's supposed to be in long before that, and I can't figure out why you would send something. Did you expect that we were sitting here at 5:30 at night waiting for your answer?
No, Your Honor.
All right. So, Miss Wolfram, can you state what it is? I understand you need to clarify when's pickup or when the parenting, I should say, when the dinners are supposed to take place and where, and
it's just actually a little bit, obviously Your Honor knows that the relief was sort of off the top of the court's head, which is totally understandable. So we didn't really have a chance to flesh out the details. And in the interim, there's just been a lot of hardship caused by, we just want some parameters. Unfortunately, this is not a case where, for instance, my client reasonably asked for 48 hours notice, and there has been just an incredible pushback about giving a couple of days notice about where it's going to be. The order also specifies that it's near the kids' location. The kids attend school in Holland. Mr. Quano is well aware of that. He keeps picking places in Grand Rapids so that she has to drive back and Allendale, so that she's having to drive back and forth between. And so we're just asking for some reasonable accommodations. So again, I want to make it clear that we are not objecting to the relief granted, not even really objecting, although I think at this point it might be easier to just set a specified location, at least during the school year. But it is just become abundantly clear that, 56 messages to arrange 4 dinners, that Mr. Quano just simply cannot adhere to these reasonable requirements. So if we can just ask the court to clarify.
all right, Mr. Quano, what's your problem with this?
Well, I also have some just general questions on clarification, but in response to what she said, I've been giving them at least 24 hours notice. I've been asking their input. One thing that
has had whose input?
Well, sorry, I've been asking mother's input. There have been at least 5 separate, unique sort of factors when it comes to these specific children and eating. In the past, she's asked me not to get them certain foods when I was working with Herbalife Nutrition. There's a lot of parental issues around sort of allowing them to eat what they want. There's allergies, there's religious and kosher restrictions, and the mom is big on meal planning. So I thought it would be nice to say, hey, here's a few options back, right when we started. And okay, here's a few options, and I'll let her respond and give any kind of input. She refuses to do that. And so I have to.
Where do you want to have dinner with the kids?
I'm happy to just name a location if that's what it's come down to.
I'm asking you right now, where do you want to have dinner with the kids?
Next week?
From going forward?
Can I pick multiple locations or just one?
No, this will relieve everything if you pick one. It's got to be within a reasonable distance of the kids. I'm not going to make her drive to Grand Rapids.
Okay, let's do Taco Bell in Allendale, where we've been the last 2 weeks.
Your Honor, I again appreciate the accommodation, but the kids go to school in Holland. And so what they do is they leave school, they do, homework and stuff in the area, they have dinner, and then they go home for the evening. So we've asked that it be in Holland a number of times. And there's
but it can be within 50. How far is Taco Bell in Allendale from?
10 minutes. It's absolutely 10 minutes.
From their location?
From home, it's like.
I'll let her answer.
Holland, it's like.
Go ahead.
So from home, our house is between Allendale and Holland. So from home, it is only like 10, 15 minutes from home, but from Holland, where they're coming from, it's more like 45 minutes.
But they don't, but they come home first.
Correct.
Sometimes they do. Sometimes they do come home first. Sometimes they have extracurricular activities. Our youngest son is in cross country right now and has practice every day until 4:30. And it also is a lot easier on them from a stress standpoint to just be able to go out to dinner when they've expressed to me that it's really stressful to come home, be home for like 10 minutes and have to turn around and go back out again. So after they're driving home for the day, it just makes their whole day a lot longer when we have to go home and then go the opposite direction rather than just being able to be in Holland.
Well, Mr. Quano, I'm talking.
I'm sorry.
It seems to me that if they're done with practice doesn't he only get them at 6 o'clock?
Correct.
Well, if they're done with cross-country practice at 4:30, I mean, how far is it to get home? A half hour, 5 o'clock?
Yep.
All right, well, I mean, otherwise, if I put someplace in Holland, they're gonna sit in Holland from 4:30 till 6 waiting for them?
So that actually gives them some time to do homework before dinner. So we can go to, there's a couple coffee shops they really like, a couple bookstores, libraries. That gives us an opportunity to sit down, go through their homework for the day, and for them to get all of that done before dinner. That way, once they're done with dinner, they can just come home and be home for the night. Otherwise, they don't have enough time to come home, do any homework, get settled in, and then leave. And then effectively, they just can't do any of that until later in the day, or until they get home at 8 o'clock.
So what are you proposing then?
One location is wonderful. That would.
I'm asking you, what are you proposing then?
Any location in Holland. I mean, Qdoba is great. Tropical Smoothie Cafe, Salt and Pepper is a restaurant that they really like. If they want to do something not fast food, Subway. I mean, there's a lot of location options in Holland that would all be fantastic.
Mr. Quano, how about Salt and Pepper, a restaurant they really like?
I did want to clarify first if it's okay to take the minor children to a place that serves alcohol. Is that all right?
Does Salt and Pepper serve alcohol? I mean, you're not serving alcohol, so I don't care.
Okay, so that's fine.
Salt and Pepper, she just said Salt and Pepper is a place that they really like. Is that correct?
I've heard of you mention it. No, I object because the first week of school, my eldest son, when I had him for dinner, when I did go to Holland, I changed the plans to accommodate. My oldest son said he was really tired from his first day of school, and he said it like twice to really emphasize it. So I said, that seems like a problem. And his brother, his middle brother, apparently the mom's telling me he's had a lot of trouble with homework. So my thought was, and I told her, they shouldn't be doing extracurricular activities. They should be going home.
That's not before me.
Okay.
And to me, it seems like you only got one son, and ma'am, what do? You go pick up the kids, all of them, at 4:30 or 3:30 or what?
It depends on the day. It depends on there's a homework club at school that is an option sometimes for them. It just depends on the day. The only set thing is Amati's cross country schedule. But yeah.
Do you know where Salt and Pepper is, sir?
I've driven past there. I wouldn't want to set that to the location because I've never been there to check it out. And I offered to take Amati home. Last time we were on July 28th, Ms. Wolfram said that I could take the kids to their sporting events. I don't see what the difference is between taking them back to the older children.
I'm not here to re-argue anything. I'm just here to clarify the prior order and to set a place and time for the kids to meet with you for dinner so that you don't have to have any exchanges about it. She will have the kids there at 6 o'clock on I think it's Wednesday, is it? And that's just coming from memory. So every 6 o'clock on every Wednesday. And you're saying, ma'am, that there's appropriate food that the kids like at this place.
Yes, Your Honor, there's no question. I mean, all of those other concerns he has are not real. There's no restrictions or anything like that. He can pick any place. We're not complaining about that at all.
I never said there was restrictions.
She's given you a couple of options. Salt and Pepper. What was the other place?
Qdoba, Subway, Tropical Smoothie Cafe is a place.
Red Robin is right in that same area. They like Red Robin.
Which one do you want, Red Robin or Salt and Pepper, sir? I'm giving you your chance.
Okay, so I don't get to object that the kids should go home and I can pick a location in Allendale instead?
No, I'm telling you right now, she's given you some places. We got to get this going, and this is ridiculous that we can't even pick a place and get it. So, and she doesn't want 56 text messages to try and pick a place. Well, if you aren't going to pick it, then I'm going to pick Salt and Pepper, which I don't know at all, but I'm going based upon mother's representation that that's a place the kids like, and I can't imagine why you wouldn't want to take them to a place that they like.
Can we pick a Taco Bell in Holland?
I don't know. Is there a Taco Bell in Holland?
Yeah, there are several.
Which one are you talking about?
Sorry, I didn't come researching all of the different locations. This is not where I thought we'd end up. So I can pick one and message her in the next few hours.
No,
I can pick one right now.
All right, pick one right now.
You have to give me one moment to look up locations.
Whatever's on, I'm trying to think what's on the north side of it.
Well, why don't we have the mom pick it so it's most convenient?
Ma'am, you can pick it.
There's this one up here would be the one on 31 would be the closest.
Sorry, I'm trying to zoom in. I apologize.
Shore Drive, Holland.
I'll go check it out.
And it's 6 o'clock till 7:30. Is that what it is?
That's right.
All right. That'll be it.
Your Honor, there's a couple of other reliefs. We requested a potential 4 days off. The kids have various activities and things. And again, these parties are not really able to communicate with regards to like, for instance, she said finals week might be a week that it would be nice not to have this obligation during the time that they're supposed to be studying because they don't get to set their tests and things like that, or a vacation. We just ask that she be able to use for her calendar year that would be excused.
I object to that. She's
First of all, I've got this.
Okay, I'm sorry.
I'm not going to set that she gets 4, if you will, free passes. If something happens and is necessary, and because I can't micromanage this.
Understood. Understood. And I think the rest of it is pretty much covered. I guess I would just ask at this time that the court, perhaps give an opinion on, Mr. Kawano has attempted to keep the children after the 7:30 expiration of parenting time and indicating that, somehow that's a wrong thing for them to leave at 7:30. That's
not true.
The order is the order. It's 6 to 7:30. I'm not going to issue an order that says he has to follow the order.
No, of course not.
Well, okay. I had an incident just on Wednesday where finally breaking through to my oldest son, and he was opening up to me. He was talking to me about the possibility of visiting me on weekends. He was trying to just kind of cry.
That's not before me. Okay. That's not before me. If you want to make a motion to change parenting time, you're going to have to show proper cause of change of circumstance, and then we'll have to have a hearing on it or whatever. I don't know what's going on, but all I'm trying to do is get the original order in it. All right.
Okay. Can I make a couple more requests for clarification on just about what was said on 28th? The transportation, it says, I believe you said she may pick them up and drop them off. The order now reads, she may participate in transportation. She has been she doesn't want me driving them, but she does send other people to drive them too. So is all that okay? Is that what you meant? What's going on with that?
Ms. Wolfram, I'm assuming that Mom, we've just gone through this whole thing. Mom's dropping them off and picking them up. She dropped them off at 6 o'clock and she'll pick them up at 7:30 or have some other appropriate adult there to do it.
That's 100% correct. The order actually reads may provide transportation. I can say that she must provide transportation. She's comfortable with that too. She will be the parent providing the transportation to and from parenting time or appropriate substitutes like a step parent or, family friend or somebody who can transport the kids.
Right.
Okay. Another question is, has this, adjourned or removed her at her sole discretion and we can't have any other parenting time? Have the Tuesdays that I've been doing it for a year at the library and the Sundays I've been doing on Zoom for over 2 years, are they now removed from me? My understanding was this was adding to my parenting time, but their understanding is that those have been removed.
I believe we were just setting a time for you to have parenting time so that we weren't looking at all different things all over the place. I recall that, sometimes the kids didn't show up or weren't there and all that kind of stuff. It's for the kids to meet you at Taco Bell for an hour and a half on Wednesdays. And we can look at some additional time later.
Okay, so what I've been doing before, we're not doing that anymore. It's all been changed to the Wednesdays.
One Wednesday from 6 till 7:30.
Okay. Hang on, I thought I had another question. Is there any chance I can get some special time for their birthdays? or is that going to be another motion?
That's not really before me. The only thing before me right now is clarifying my prior order. If you want additional time, you can talk to Ms. Wolfram, who is the attorney for your ex-wife, and you can talk to her and see if you can negotiate something. If not, then you'll have to come back on a motion.
Yeah, okay, so I'm got a follow-up question, which is, then my understanding is parenting time is no longer at her sole discretion. I've been trying to speak with the mother directly, but it doesn't seem to be working out. Are you saying I should try to talk to the lawyer then, Ms. Wolfram?
If you want to negotiate something, I suggest you contact Ms. Wolfram, who will deny or agree, or will talk to her. Your ex-wife doesn't want to have contact with you because you abuse it, in her words, okay? 56 times to set up 4 parenting times is ridiculous.
That's not what happened. That's not what the content of the message is.
Sure, you're going to say that. I don't know why you would contact her 56 times regardless. She doesn't want to have contact, and so you're going to have to work through the courts and or Ms. Wolfram. Unless Ms. Wolfram indicates that she has withdrawn as her attorney, then you will work through Ms. Wolfram. Good luck, everybody. You can modify that order to indicate the address and the place that is to be picked up and all right.
I will do that. Thank you.
Thank you. Good luck. We're adjourned.
Yeah.
Now that I'm in a really bad mood. You're next. Both parties are present. Mr. Ryan via Zoom is injured here in the courtroom. This is regarding a temporary order in a custody case that was just filed on 8/24 of 23 by Mr. Ryan. It's dealing with 2 children, Harper and Owen. The first thing I have to ask is, does anybody have an affidavit of parentage for these kids to establish his legal right?
I mean, I don't have a copy of one right now. I can get one if I need to.
Did you both sign an affidavit?
He did sign.
Yes.
He did sign it for both kids?
Yes.
Yes.
Okay, and obviously you have to sign it too. So
Yes.
I can operate under the assumption that there is one available. If I, it should have been filed with the state of Michigan, but as long as everybody agrees that there was an affidavit of parentage that is signed and makes you legal father, I'll proceed, okay?
Yep.
Where the kids attend school at this point? It's public school.
They were enrolled at Chandler Woods to start the year. They started the year there August 21st, and then Kaylee pulled them out halfway through the day, and I have not seen them since. There was no discussion of changing the schools that we were enrolled at.
Well, but
the last discussion we had was at Owen's IEP meeting at Northview, and we were all set on Chandler Woods for everybody.
okay, but as of now, I don't believe you have any legal custody of the kids, if you will.
They've lived with me 50% of the time forever.
That's different than having a joint legal custody agreement. That's a court order. The only court order that I don't see any court orders regarding.
No, there hasn't been any. There hasn't been any. I filed it when I found out about Owen not being biologically mine, and she talked me out of it. So
I showed up for court and he did.
That's not true.
With like a paternity test, we can get that. There is also a court motion filed in Mecosta County for an official custody order.
You filed.
She moved up there and then filed.
One at a time. She moved to Mecosta County and you filed a case for a custody case?
Yes, we're just waiting for a court date.
When did you file a custody case there?
He was served with that paperwork prior to him serving me with this paperwork. So it was filed. This one is mine. It was filed. I believe it was end of August.
Well, he filed his August 24. I can confirm that.
Yeah, I have the order.
And I didn't have a proper address for her. I had no way to serve her.
Well, all I'm saying, I'm trying to figure out whether or not we even have jurisdiction or not, because if she has a custody case that predates ours, it might be that I don't even have jurisdiction, and you may have to go up to Big Rapids to fight it.
Acosta told me that jurisdiction would land here. And we've lived in Kent County they've lived in Kent County their entire lives. We all have.
Until very recently?
Until days before school started and all of this happened without my knowledge.
Right. It looks like she filed one day before you. The only question will be,
there's nothing officially stamped on it, but
well, there's a seal on this
then it was.
that she filed a day before you. And how long had you even lived in Mecosta County?
We have lived there since end of school year last year, so.
That's not true. They lived in Rolling Pines off of 5 Mile.
I did have an apartment there, and my lease did not end until July 1st. But we started the moving process mid.
Did you say you moved on at least by July 1st?
Yes, yep.
That's not true.
How am I gonna determine where she lived?
My address has been officially changed with the postal service on my.
When was it? Can you show when it was changed? Because I'm just trying to determine whether or not I even have jurisdiction. If the kids have been living in.
My ID is dated 8/8 is when I changed it on the ID. As far as with.
When did you rent someplace or move up there?
My boyfriend actually lives there and he owns a home, so we moved into his home.
And you're saying you moved up there by July 1?
Yes.
That's not true.
Well, how do you know that?
Me?
Yeah.
I'm just going by what my daughter tells me.
Well, your daughter's only 6 years old.
But I picked them up from the apartment that they lived at every time on my scheduled times to get them. That's where they were.
For the pickup as to not disrupt that until we had a court order. So I have been driving them back and forth to Grand Rapids so that he could get his parenting time.
Kaylee's cut off all contact to me since last spring. I've had no way to get a hold of her. She gave me an email to get a hold of her at that doesn't exist. I send weekly messages to check that it doesn't exist. Still, we did occupational therapy. She was there. She never mentioned anything about moving to Big Rapids or about taking the kids out of their school. I made it very clear the Friday before school started at occupational therapy that the teacher was ready to be in contact with the occupational therapist. Also, the occupational therapist at school was ready to be in contact with her. I passed along all the information and made that very clear right in front of Kaylee, and she never once mentioned that they weren't going to be attending that school.
You mean Chandler Woods?
Yes.
Did they attend Chandler Woods?
Yes. Harper's attended there since young fives, and she's now in first.
I'm talking this year. Did they attend there?
They were there the first day. I dropped them off. We went to orientation the Thursday before. I dropped them off on August 21st.
You re-enrolled them there?
Yes.
When did you re-enroll them there?
Last spring, whenever enrollment was open.
This was happening last spring. I pulled them out. He got angry, made threats, told me I wasn't allowed to move. I'm well within 100 miles.
That's false.
Well, I mean, there's no order that doesn't even allow you to move at this point because there's no custody order or anything.
So that's the whole issue is that's the only thing he's hanging on to is the school situation because
No, I'm hanging on to being my kid's dad. What's best for them.
How often were you seeing the kids?
I had them every other Thursday night and then every Friday, Saturday, and Sunday night for over a year. 50% custody, 50% shared time.
And I can't have both of you talking because I can't hear either of you. Yeah, you're saying that he had every Thursday night?
he tried to take them every other Thursday night. He would show up at school and refuse to allow the adult that my daughter was supposed to go home with to take her.
But there was nothing in writing about anything.
He would just show up and take them.
There's no custody order. There's no parenting
I
time
was
order.
trying to work with him to keep some kind of consistent schedule. He won't allow me to have them for a weekend to do a birthday party, for our child.
Does he see it all now?
Once he sent them to school, there was a big issue once we.
I'm just asking a question. That's kind of a yes or no type thing. Does he see him at all now?
He has not seen them for a couple of weeks because of.
Since the end of August?
Since August 21st.
Okay. All right, my biggest problem is going to be, I have to figure out whether or not I even have jurisdiction to make a court order. Because if she beat you to the court and the kids are a resident of Mecosta County, which she would have to basically indicate that they are, and she's saying that the kids have, for all practical purposes, lived in Mecosta County enough to establish the residence, then I won't even be able to give you parenting time.
What about the residents at my house though? They've lived with me as well. And they haven't lived in Big Rapids since July 1st. I don't think her lease was up till August 1st, honestly. I'm pretty sure. I mean, I can look back through text messages right now from her cousin who made me aware of it. If I can do that right now and give you a date.
What I'm really going to have is some type of a hearing to determine what is the appropriate court before I can issue orders. I don't know, because I also have the Mecosta County courts telling me that they have a court case filed regarding custody of the kids prior to yours. Okay. I mean, I saw the document here that says they've issued something on 8/23. I think a summons on 8/23 that they've issued, and you filed on 8/24. All right. So I got to find out whether or not whether residence is established sufficient to allow for the 8/23 to win, or do we win? And I can't do that this morning because it just doesn't, I don't have the ability to do that on a Friday morning. I've got to try and figure out and whether or not she can prove that the children were residents of there. I mean, they might be residents here and there, in which case then the first filer probably wins. If the residents of Kent County and Mecosta County, I would think then the first person to file wins. And you'd have to go to Mecosta County to do this. But you're saying she doesn't live there. She's saying she does. She's saying she's lived there since basically July and had the kids basically with her up there since July. Are you telling the truth on this, ma'am?
Yes.
Then so the best that I can do right now is adjourn this, and I might have to send out something to find out which court has jurisdiction of this. So I'm gonna adjourn this motion for 2 weeks, see if I can determine that. And at the end of 2 weeks, we'll have to see what happens. I'm not gonna pull the kids out from where they're going to school now. I may, if it turns out that, you know, that I have jurisdiction. But even if I do, I'm not going to, at least at this point, pull the kids out because they haven't been staying with you as much as they stay with her. I'm gonna have to figure everything out.
I've been there to pick up my kids every day I'm supposed to.
I'm not saying you haven't. I'm not
Okay.
trying to make you a bad father or anything, okay? I'm not, and I understand what you're trying to do. I do, and I have great sympathy for you. However, the bottom line is I can only deal with the court orders and stuff like that, okay?
I understand.
And I'm trying my best. I don't know what should happen. What I know what should happen is the two of you should sit down and figure something out, because she obviously is going to live up there with her significant other, and Big Rapids is a ways away, but I had a stepdaughter who went there, and we used to drive up there every time I'd look, be turning around, and it is only about where do you live, sir?
I live on the northeast side of Grand Rapids, Eleanor and Plainfield.
All right, right near me. And so, I mean, it's really not an overwhelming trip. It's not like going up to Cadillac and stuff like that. And so, the two of you should talk in the meantime, but I'm gonna I'll adjourn this 2 weeks and see if I can come up with an answer as to whether or not I can actually do this.
I have no way to contact her, to talk to her, or to even check on my kids.
Ma'am, if nothing else, you should allow him to see his
It
kids.
wasn't the intention of trying to keep the kids. It was an intention of.
She's done this multiple times.
Just Mr. Ryan, stop. All right.
I just didn't want him trying to send them back and forth to different schools. And that was my concern.
I would tell you right now that why can't he see his kids this weekend?
Absolutely can. I just need to know that they're going to come back for school.
Mr. Ryan, if she lets you see the kids this weekend, I don't know where you'd pick them up.
Yeah,
but
no, he can pick them up from school today if he's gonna return them Sunday at 5, or I.
Will you make an agreement to do that or not?
I don't even know where they go to school, sir. I can't pick them up from school. I would agree for her to have them dropped off to me by 6 p.m. tonight, and then she can pick them up this weekend, because I don't even know where to go. She moved, and she's kept my kids from me.
I'm trying to give you some parenting time right now.
I need one way or another, though. Either she gets them to me tonight and I get them to her Sunday, or I get them tonight and she picks them up Sunday.
Why don't we do what's halfway between Big Rapids and, I mean, there's the Newaygo exit, there's the.
Newaygo probably. It's about halfway.
We meet in a public place, please.
Yeah, no, I want to, and there isn't at the Newaygo exit, there isn't a public place. There's what's this side of the dump?
There's a gas station right there, right? Is that Newaygo or Pearson I'm thinking of?
I think it might be Pearson, because I don't think I used to go up to Newaygo all the time for cases, and there's nothing when you pull off, at least the Newaygo exit that I'm aware of, which is,
thinking of Pearson probably.
Is there a gas station at the Pearson exit?
I don't know that exit. I know there's a park and ride at the Sand Lake exit, but that's not really public. That's kind of a.
Well, there's gas stations along 131.
Yeah.
At some.
If you're willing to drive to Sand Lake, just go to Cedar Springs and I'll meet you at Big Boy.
That's in no way halfway.
Well, but this is one time. One time. Okay. The Cedar Spring exit is like, it's 29 miles or something from yours. Okay. I think, because it's like exit 110 and you're 139 for Big Rapids. I don't know where you live in Big Rapids, but how about just this one time, because I know there's a gas station there.
Peter Springs exit? Or
Yes, there's multiple. We lived right there, Kaylee.
Which,
I'm just asking which.
yeah, which one? Is there a Myers there?
There's a Meyer right there.
To
Just
the,
west of the highway.
why don't you meet at the Myers gas station at the Cedar Springs exit at 6 o'clock? Does that work for you? Can you get there at 6 o'clock? Can you get there at 6 o'clock?
Yes, sir.
And I want it on the record here so that in case you don't return the kids, there will be an exchange at 6 o'clock on Sunday also, correct?
Yes.
You can pick them up there. I'm sorry, you might have to drive a little extra, but you are the one who moves the farthest away too. So 6 o'clock Friday through 6 o'clock Sunday, you both agree to do that from the Myers gas station. Act like adults because your kids will be watching.
Yes, sir.
Right? And I'll see you in 2 weeks and see what I can come up with. All right?
Yep. Thank you.
Good luck. Thank you.